With the current ruckus political dispute brewing within the Senate leadership, it was fortunate that Keith Bybee accepted the invitation to come inform us all as to the nuances of that particular brawl. A subject that some of my more learned and opinionated subjects, acquaintances, has turned the U.S. Senate screw up. I cleaned that up. Professor Bybee is a Paul E. and Honorable Joanne F. 72 Judiciary Studies Professor of Law at the University. He holds tenured appointments at the College of Law and the Maxwell School of Citizenship and Public Affairs. Let me just stop for a moment. He is also on the part of the chair of a afternoon law, politics, and media series at Syracuse University. And they miter in politics, law, and media to the scheme of things. And they're bringing in scholarly academics, media people that are very interesting and very aware and astute. He also directs the Institute of Study of the Judiciary, Politics, and Media. That's the law, politics, and media that I just told you about. A collaborative effort between the College of Law, the Maxwell School, and the Newhouse School of Public Communication. Keith's areas of research interest are the judicial process, legal theory, political philosophy, LGBT, hope you understand that, the politics of that aspect, the politics of race and ethnicity, American politics, constitutional law, and the media. His books include Mistaken Identity, the Supreme Court, and the Politics of Minority Representation, the collusion of courts, politics, and the media, and all judges are political except when they are not. Acceptable hypocrisies, and the rule of Stanford, the rule of law. As my bubby, I hope you guys know what a bubby is, as my bubby was heard to offer, go figure, or was it, it figures. A warm, manliest welcome to our speaker, Keith Bybee.
Thank you, Louis. It's a real pleasure to be here. I should mention just to kind of shill my forthcoming book. I have a book that's going to be coming out in just a few months. Is this on? No. It's not. Can you hear me? Anyway?
Some of them can.
Okay. This is important because I'm about to. You can keep talking. Okay. So I got a new book coming out soon. It's on civility. It's called How Civility Works. I'm not going to talk about that today, but we hope to get it out before the election. Very timely.
Hurry up.
Hurry up. Okay. Says that.
No, I have some work to do.
Okay. So the idea is to talk not only just about the current controversy over the Supreme Court and the Merrick Garland opening, but also to have Q&A, just discussion about the court generally today. So I'm not going to go on at length about the Merrick Garland controversy. I'll speak for a little bit, but I will. Okay. Okay. Is that better?
Yeah.
All right.
Yeah, thank you.
So I'm going to speak about the Merrick Garland controversy a bit, and then hopefully we can talk about the court more generally. But I will be brief. I will try to follow, in fact, FDR's advice when he said when you're addressing a group, you should be brief, be sincere, be seated. His advice. I will try to follow this. So what am I going to say about the Merrick Garland controversy? I want to make two general points. One is, I think when we look at what's going on right now, it teaches a particular lesson about American politics generally, but specifically about the politics of the Supreme Court. And that's, I think, one story, and it's pretty accessible, and I'll go over that. But I think there's also a second lesson, a kind of deeper lesson about this current controversy that tells us something maybe a little less obvious about American politics and the politics of the court. And I'll want to talk about that deeper lesson too, and then we can talk together. So Merrick Garland controversy, what's going on? In February of this year, Justice Antonin Scalia passed away. His death was somewhat unexpected because it was not publicly known that he was in poor health. In another sense, though, I guess in an actuarial sense, his death wasn't unexpected. If you look at the average age of retirement for justices in the Supreme Court from 1960 through the current day, the average age is 79. Justice Scalia was 79, which doesn't mean that he was going to die, but it meant that it was a good chance that he was going to leave the bench. There are currently 3 justices sitting on the bench who are at or above this average retirement age. This is in addition to Justice Scalia, so we're going to have more vacancies coming. The day after Justice Scalia died, Senator Mitch McConnell, who's the Republican Majority Leader in the Senate, announced that there would be no confirmation hearings in the Senate, no matter whom the President nominated for Justice Scalia's seat. President Obama responded by saying, oh yes, there will be a nomination and there will be a hearing, he believed. And about a month later, he did indeed nominate someone, Judge Merrick Garland, who's the Chief Judge of the DC Circuit Court of Appeals, where he has served for 19 years. So that's just a little bit of background. I'm sure all of you were aware of that. So first, what does this episode tell us? We still don't have a hearing, right? No hearings have happened. It's not surprising in a way that a partisan political fight erupted immediately over this seat. Now, why would that be? Right now, or really in 2015, when the Supreme Court's term began, the court was split not only between liberals and conservatives, as it often is, but all of the liberals on the court were nominated by Democratic presidents, and all the conservatives were nominated by Republican presidents. So we not only had a split between liberals and conservatives, it was a partisan split that mapped directly onto the parties. So for those of you keeping track in the audience, Ginsburg, Breyer, Kagan, and Sotomayor, all nominated by Democratic presidents, and Alito, Scalia, Thomas, Kennedy, and Roberts, all nominated by Republican presidents. The Supreme Court often divides between these two blocks. Not always. Last year, if you look at the Supreme Court term, 40% of their decisions were unanimous. You might say, that's great. 40%, that's amazing. We don't hear about unanimous decisions usually when we talk about the court. Well, there's a reason why unanimous decisions aren't widely reported. Number one, they're often not on the most controversial issues. But number two, this unanimity is not really rooted in agreement, right? And how can that be? How can you have unanimity and not have agreement? This measure of unanimity is when all the justices agree on the result. That is it. When they agree on the result, not when they agree on the reasoning. The Supreme Court, they write opinions all the time, multiple opinions, not just dissents, but also concurring opinions. In fact, when Justice O'Connor was on the court, she once wrote the majority opinion in a decision, and then a separate concurring opinion, concurring with herself. So the Supreme Court justices write lots of opinions. If we look at unanimity, a real measure of unanimity would be not just agreeing on the result, but agreeing on the reasoning. When you look at that, it's not 40% of the decisions that are unanimous. It's 8% of the decisions. 92% of the Supreme Court's decisions feature real disagreement. Not necessarily on the result, which can sometimes be very narrow, but on the reasoning to take to that result. And oftentimes, this disagreement is patterned. There's a partisan pattern to it. 26% of decisions last year were actually 5-4. 5-4 and politically divided 5-4, most of these. That is, with the 4 liberals on one side, 4 conservatives on the other side, and Justice Kennedy, who's the most moderate justice, swinging back and forth. Those decisions are often the ones that come out this time of year, right? The court waits until June to issue its controversial decisions, and they're 5-4. So, when Scalia died, and you have this fight emerging right away between Senate Republicans and between Democratic president, in part it's not surprising because the court is already divided on these political terms. The court is not only divided, it's not balanced. The New York Times for a while has been running a number line. It's been a while, I don't know if last time you guys dealt with a number line, it's been a while for me, but if you my children deal with number lines, big second grade activity. So you think of a 0, right? Imagine me as a large 0 right in the center. You can array the justices either to the right on a number line for being conservative or to the left. The New York Times has been running a number line for a while, showing that there are a bunch of justices to the left. There are the ones who are the liberal justices appointed by Democratic presidents, and those to the right. It makes it look like, oh yes, it's political and it's balanced. It's not balanced. This court is actually, they've got people on the right and the left, but it's a very conservative court. By the measure that political scientists use, Justice Thomas is 50% more conservative in his voting pattern than Justice Sotomayor. Justice Sotomayor is the most liberal justice on the bench right now, on the high bench. So if she's at a 4 over here, a -4, let's say, liberal, Thomas is at a 6. Justice Alito is as conservative in his voting as Justice Sotomayor is. But Justice Alito is only the 3rd most conservative justice on the bench. Thomas and Scalia had more conservative voting patterns than he did. So think about our number line. Okay? At 0, we have moderate. No one's at 0, by the way, on the court. You have liberals clustered over here between like 3 and 4, and you have most of the conservatives between like 4 and 6. Kennedy, who's the swing justice, is between 1 and 2. People believe that anybody, including Merrick Garland, that President Obama nominates, will be over here on this side of the 0. What does that mean? Well, for Dow Chemical, that meant $835 million. Dow Chemical had a lawsuit. They were facing class action lawsuit from their paint suppliers. Not you and me who buy paint, unless you guys own paint stores, but the paint stores that the Dow Chemical sold to. They lost at the trial level, and they were slapped with a $1 billion settlement. So Dow appealed to the Supreme Court. The court agreed to hear the case. And the conservatives on the court have many questions about class action lawsuits. They don't like them. They make it harder to form classes over time. This is the direction the court has been moving. When Scalia died, Dow Chemical realized they were most likely not going to win the Supreme Court. So they settled. The first result of Scalia's death was an $835 million payment by Dow Chemical to these plaintiffs. The New York Times did an analysis based on the work of law professors and political scientists and found that 67 landmark cases are likely to change based on whomever the president, a Democratic president, gets on this polarized court that has been not just polarized, but a conservative court. So, Justice Scalia dies. To use, all hell breaks loose. I don't know if Lewis used that strong language, but I think it's required, right? So this political firestorm breaks loose, and it makes sense given the political divisions on the court. The balance of the court is at stake, and it's not just going to be an incremental change. If a Democratic nominee is confirmed to the bench, it will be a change across the board in a wide number of areas of law. So what? Why should we worry about this? This is a problem. Well, if you think democracy is, in a basic sense, that the people make decisions, about the people govern themselves, then this is a problem. And it's a problem in 2 ways, right? One, we have this court, it's only got 9 people on it, most of the time, it's got 8 on it right now, and they're making decisions. When was the last time you voted for a justice on the Supreme Court?
You never did that.
You never did, that's right. So we have this very powerful body that is not politically accountable. So if we think it's a problem for democracy. It's also a deeper problem, right? If you think of the reality of democracy is showing up. You have to vote, you have to attend meetings, you have to pay attention to things, right? It requires work. If we're delegating all these tough decisions to an unelected Supreme Court, then we're allowing them to make decisions, but it's a kind of corrupting process, right? We don't engage in the work that's necessary for self-government. It makes us lazy. This argument, by the way, is a very old one, over 100 years old, critical of the Supreme Court. So that's one lesson you can take from this. Court's political, it's powerful, it's disastrous for our democracy, right? And it is corrupting us. Welcome to America. That's one lesson, okay? But there's another lesson, which I think has the advantage of explaining more of what we see. It's not necessarily an uplifting lesson either, this second lesson. So Yeah, I know, but there are muffins, right? So that's a plus. Don't forget there are muffins, no matter what I say, there are muffins. Okay, so what's the second lesson? What's the second one we can draw from this? And I say kind of gives us a different picture maybe of the court and of American politics. It's not just party divisions and arguments between partisans, but maybe something else. There is something else going on in this Garland controversy, and that is people are talking about principle. They are talking about principles, not just Democrats versus Republicans. I mean, you can certainly look at it that way, right? And that's the way I've been talking about it. You can even find politicians who will occasionally talk about this strictly in political terms. Senator John Cornyn, who is a senator from Texas, and he's in the leadership among the Republicans in the Senate, has talked about this purely in political terms. Right? He's like, this is going to help Republicans, it's going to help the Democrats, and we're back to the line of scrimmage. So he used football terms too, right? That's how you know when you're really talking about politics. So what's the principle that people have been talking about? Well, President Obama, when he nominated Garland, he said, look, we can't let the court be connected to politics of elections or the politics of our legislatures. The court is supposed to rise above politics. This is not about Democrats versus Republicans. This is about constitutional process and constitutional duty. The court is not political, and President Obama said, I'm not acting politically. I'm acting with regard to my constitutional duty. That's what he said. So who was acting politically, according to Obama? Well, it was Republicans. Right? Republicans were acting politically. They're destroying the court. They just want to pack the court with their partisans. So there's talk of principle by President Obama. Of course, there's talk of principle also by the Republicans. Senator Chuck Grassley, who chairs the Judiciary Committee in the Senate, which would have hearings if we ever have them, right? He will run them. He has said, look, the problem is that the president is wholly political. He's untethered to the law, right? And the problem also is the Supreme Court itself is just votes on the basis of partisan preference. And then he clarified that. He said, I don't mean everybody on the Supreme Court. I mean the Democrats on the Supreme Court. So there's talk of principle in this debate. And the thing is principle is something, that's what you assign to yourself, right? And politics is what your enemies do. Okay, does this sound familiar? Have you ever noticed this? Principle is my position. My position is principle. It comes from the Constitution. Your position is partisan. It's politics, right? And we routinely see this happening all the time. The president will stand up and say, it's time to stop playing politics. Really? So we have these principles. And you would say, okay, well, why should we even pay attention to these principles? They seem to be just paper-thin justifications for partisan positions, right? And so why should we even sort of say that there's something particular going on when politicians bother to justify their position, not just by pointing to their party affiliation, but by articulating some impartial constitutional principle? Why does that matter? I mean, it seems to just be fake, right? Well, I don't think it's wholly fake. And I think it actually leads us to a more complicated view of democracy than the people decide. Remember, there was a guy up here just moments ago saying democracy is the people decide. The guy looked a lot like me, right? And we all agree that's what democracy is. But is that really what democracy is? The people decide. Isn't that simple? I don't think it is. And there's a long tradition within our country saying democracy is actually something quite different. So let me take you back to a different big decision, not how do we get a justice on the Supreme Court, that's the decision we're facing now or not facing now, as the case may be. But instead, let's go back over 200 years to the decision of whether or not to ratify the Constitution. First giant political decision made by the American people, right? In that process of ratifying the Constitution, the Federalist Papers were written. Everybody heard of the Federalist Papers? You've all heard of the Federalist Papers, so I love about this audience, well informed. My students haven't heard of the Federalist Papers. So Federalist Paper number 1 was written by Alexander Hamilton. Recently has a musical out on Broadway. 5th highest grossing musical this year. Or only 5th, can you believe that? Only 5th.
Well, it's not done yet.
Not done yet. That's right. That's right. But Lion King is still the king. Yeah. That's crazy. Yeah. So Hamilton wrote Federalist number 1, and he said, "Look, we got a big decision here. This is a huge decision. In fact, this is a historic decision because what has happened is usually people choose their government. They don't choose it. It happens by accident or force. we have an opportunity to choose our framework of government, to act on the basis of reflection, rather than just be subject to accident or force. It's extraordinary. We get a chance, we the people, which of course was circumscribed in a lot of ways at this time, obviously, who counted as the people. But that we can make a choice. It's our first big choice. The people get to decide. And he said, you would expect, given how historic this is, how big the stakes are, you would expect, this is what he said, that we would hear deliberations that are, quote, directed by judicious estimate of our true interests, unperplexed and unbiased by the considerations not connected with the public good. He said that's what you would expect, but that's not what you're going to get. What you're going to get instead is a bunch of conflicting interests, and you're going to get, quote, a torrent of anger and malignant passions that will be set loose. So we have an opportunity, Hamilton is saying, to actually make a decision about the kind of government we have. But we're not going to see people acting on the basis of common good. We're going to see them acting on the basis of self-interest, on the basis of vanity, on the basis of low passion, not high principle. And this was actually an entire theory of human nature that runs throughout the Federalist Papers. That's how Madison talked about people. He said, yeah, you're reasonable, yeah, you're capable of moral judgment, but that's not what really motivates you. What motivates you is your vanity, your passion, your ambition, your pride. That's what motivates everybody, right? And what drives us into conflict. We vex and annoy one another because we compete with one another rather than cooperate with one another in achieving the common good. According to the Federalist Papers and to Hamilton, you can't say democracy is just the people decide, because the people are the problem. The people are the source of political pathology, right? If you left people to their own devices, they will cannibalize one another. As Madison said elsewhere in the Federalist Papers, if every Athenian in ancient Athens, which had direct democracy, if every Athenian had been a Socrates, Athens still would have been ruled by the mob. It doesn't matter how educated or sophisticated you are, right? What drives us are our passions, our ambitions, and our vanity. The first object, the Federalists said, was to get the government to control the people. If you let the people control the government, we're doomed. Second object is to get the government to control itself. That was the Federalist project. You can't say self-government is just letting the people decide, because the people are animals, right? Look around you. So, how do we proceed? What do we do? Well, the Federalist solution was to force people who have conflicting interests, who don't like each other, force them to work together to get anything done. That's how our government's structured, right? You got to go from pillar to post. You got to get one law passed. You got to go to the House. You go to the Senate. You go to the President. Maybe he says no. You got to go back to the House. You go to the Senate. They overturn the veto. Then it has to be enforced. Well, you don't like it, so you sue. You go to the courts. They don't like it. You go to the House. You go to the Senate. I mean, so it takes all these players. Why does that work? That complexity is designed with this idea that if we left to our own devices, we'll do things that are destructive. Our petty motivations and our dark passions will drive us to destructive decisions. But if we're forced to work together, we'll recognize you can't just push people around. You have to make arguments that will appeal to people. Okay? This is what Hamilton said back in Federalist 1. He said, I'm not going to tell you my motivations. Because if I tell you I had good, pure motivations, number one, you will not believe me. Number two, I don't have pure motivations, right? So what I'm going to do is I'm just going to keep my motivations hidden. I'm not going to tell you where they are. Because you know that all our motivations are dark and twisted. Instead, though, I will give you general arguments, and my arguments will be open to all and may be judged by all. And the Constitutional Convention had decided that the Constitution had to go back to the states and be ratified by a supermajority of them for the Constitution to be enforced. So what was the debate over the Constitution? The debate over the Constitution was a series of principled arguments made by actors with dubious motives who were forced to work together. Think about that. Principled arguments made by actors with dubious motives who are forced to work together. Is that a description of the ratification of the Constitution, or is that a description of the current Merrick-Garland controversy? Right? I think it's a description of the current controversy. I think it's actually a description of much of our politics, and I think it's much a description of how the court operates. Yes, the court is divided into liberals and conservatives, Democrats and Republicans. But you cannot go into the court and say, I'm a Republican, vote for me, right? You can't go to the court and say, affirmative action is wrong because it's in the Republican Party platform saying it's wrong. Or there should be access to abortion because it's in the Democratic Party platform saying it should be. You cannot just make partisan appeals in the court. You have to make principled arguments. Okay? Now, these principled arguments are often made to people who have their own dark motives, right? But these principled arguments is the language in which we conduct not only our politics, but which the court conducts its business. And I think it's a mistake to lose sight of the role of principle. It doesn't mean that there really are all these purely impartial, principled people out there making decisions. Those people, by and large, do not exist. It does mean, though, that these principled arguments are made, and they are of importance. It also means that when we look at something like the Merrick-Garland controversy, that's not a threat to our democracy. That is our democracy. If we agree with the Federalist idea that we cannot say that democracy is just let the people decide. Okay? All right, I'm done. So I hope that we have an opportunity to talk about lots of things, mostly about the court, if you like, and I know we have time. So, yes, sure.
If you were president or pope or whatever,
Yeah.
what would you do, or what can we do to make the Senate do their job? Is this
Right.
malpractice when they're not voting?
That's right. I think that the only thing that can be done, right, is to place pressure on the key senators, right? I mean, the Senate has long been, and it's true for the House too, they control their own rules. Right? They control their own rules. You know, we may not be uncomfortable with the fact that they have that opportunity to decide what they want to do. In fact, if we go back to the constitutional debate, the Federalists were opposed by the Anti-Federalists. And one of the things the Anti-Federalists wanted was very short terms in office, number one. They didn't want a term in office longer than a year. The Federalists obviously went the other way, right? Senators sit for 6 years, right? The Anti-Federalists also were big believers in instructions. They didn't think, oh, you send somebody to government, they serve for a year, and then they come back. He's like, you send them with instructions. You tell them what to do. The Federalists also were against that idea. We're living to an extent, not wholly, but to a large extent, in the world the Federalists created. And so we have politicians who sit for long terms and who don't respond to instructions, right? They don't have a set of instructions. So, I mean, there's nothing you can do to get them to do it other than getting new senators, or for the senators to make a different kind of calculation about how they want to enforce their own rules. So one of the things that's going on, I think, among the Senate Republicans is this not making a judgment about the court so much as I've been talking about, but they're also concerned about maintaining Republican majority in the Senate. There's an election, right? And so even though McConnell has said there's not going to be any hearings until there's a new president, we've already heard from members of the Republican majority in the Senate that really what they mean is let's wait until after the election. We can do this in late November, right? Now, you might say, God, is this any way to run a railroad, right? Where they don't even uphold their constitutional duty. What are these shenanigans? Which I think is Gaelic for brouhaha. Well, these shenanigans, right, are as old as the Constitution itself. If we go back to the early 1800s, when the Federalists were voted out of office by the Jeffersonian Democrats, and they took control, the first thing that the Jefferson's party did when they had control of the federal government is they suspended an entire term of the Supreme Court. The Supreme Court didn't just lose a member, they were out of business, they were shut for a term. Now, the court was weaker then, and it wasn't involved in as many important political decisions as it is today. But we can go back to these early elections and see that there's been real partisan rancor and deep, deep disagreement that has paralyzed federal government around the Supreme Court. And it's not just this year, it can go all the way back to the founding. which either shows, again, it's like, that doesn't mean this is a great, like I said, my second lesson about what's going on. It's not necessarily uplifting, but I think it does give us a different view on what's taking place. Leslie. So, but I don't think that we can make principled arguments, but ultimately it's political pressure that will drive the Senate to change, I think. Yeah.
What are your thoughts about should the Electoral College stay or be abandoned, or is it an essential part of the Constitution to keep the people under control?
Yeah, I mean, I think, again, if we have this idea that the worst thing we can do is give people direct access to decision making, then the Electoral College is a good thing, right? The original conception of the Electoral College was that it itself would be a deliberative body, right? So that we would be sending people to the Electoral College in the way that we send people to the Senate now, and they would actually deliberate and make an independent decision, which is what you want, right? You don't want, again, if you share this view that the first thing we do is serve our own self-interests, that's also the last thing we do, and everything in between is serving our self-interest, so we have to find some way to get us, like you get a dog to drop a bone. So it's gonna get me to drop my self-interest and my vanity. Well, if I have to work with you, right, then we have to find some way of getting together. So the Electoral College is designed to create a layer of insulation between self-interested, passionate people and send this college together so they can deliberate. You know, one of the big problems, of course, is what's to ensure, if the Electoral College did deliberate, that they don't just serve their self-interests, right? Who's gonna guard the guardians, right? And the anti-federalists thought no one would. They thought that the Federalists were imperialists, aristocrats. They wanted to bring back the monarchy. They thought this was going to be a government that would just oppress us. But I think the Electoral College is not just there by happenstance. The Electoral College is consistent with and comes from the same ideas that led us to split the House and the Senate into two branches, that required lawmaking to involve the executive in both branches of legislature, that allowed the federalism system, right, where you have the federal government and all these independent sovereigns that are the states. Keeping all that system together is the same rationale for having the Electoral College. So I don't see it as something we can just sort of prune, right, so that doesn't work anymore. It's like the appendix or something. Like, why do we even have that thing, right? It's at least conceptually consistent with these ideas. Whether it's playing that role today, I don't think so. I mean, the Electoral College is not playing that role because we just assign it, we think it's an automatic, just automatically translates the results of the popular election, right? But that may be an argument for reinvesting the Electoral College with authority, not for getting rid of it. I'm not saying I would endorse that, but if you're a real Federalist, right, if we're all Federalists in this room, and those are the guys who won, right? If we're all Federalists, we should want the Electoral College to be more important, not less important than it is now. Yeah.
It's the job of the Supreme Court to rule based on the constitutionality of it, and yet last number of years, it seems like we've heard more and more about that they are making law instead of ruling on that. And in particular, as an individual, I'm absolutely certain that the vast majority of people in this country do not like Citizens United. And how did that happen?
Okay, so two good questions, right? I think first the idea of ruling on the basis of the Constitution versus making law, that's something we hear a lot too, not only on the court, but debates about the court. Usually it's the case that people will say, oh, I interpret the Constitution, you're making it up, but I interpret it, right? So we usually assign making law or being an activist to people we disagree with, whereas I'm committed to the Constitution. I think part of the way that Citizens United happened, right, is that it's not just, the Constitution hasn't changed, right? No word of the Constitution changed. But the court, a lot of times, doesn't look at the Constitution at all when it's making a decision. I teach constitutional law both to undergraduates and to law students, and they're all surprised that we don't spend a lot of time actually reading the Constitution, because that's not how you would understand what the court does. What the court does, the principal source for its decision making are its own past decisions. So it's a common law system that we inhabit. We inherit this from precedent, right? Precedent, exactly. And so part of any decision is you have to think about what's the state of precedent. And since the 1970s in the Supreme Court, there's been a movement from both the kind of conservatives and the liberals to be more pro-free speech. It used to be that conservatives, say in the 70s on the Supreme Court, were skeptical of free speech because they thought it would affect the morality of a community. Right? If you just allowed strip clubs to be wherever people want to put them, this could affect the tone of the community. Free speech can be a bad thing, not a good thing. This was the divide. But you've now had this kind of coming together because there are more conservatives with a libertarian orientation on the bench. So in general, number one, there's been a movement in precedent towards more pro-free speech position. I think the Citizens United thing, what's really controversial about it is not that it's just free speech, it's that money is speech, number one, right? Money is speech. Which when you think about it, and that may well be true, but it also means that some of us have got a lot more speech than others, right? But it's also, I think, underlying this is this idea that corruption is not a good reason to constrain contributions. The original thinking, and campaign contribution or restrictions on campaign contributions are quite old, they really were strengthened in the 1970s after Watergate, was the idea that if you allow for unrestrained spending, you promote corruption of the political process. Now, I was talking about corruption earlier, and that's when we let the Supreme Court make decisions for us and we become lazy, right? This is a different kind of corruption. It's the person with a lot of speech, right? A suitcase full of speech, gives it to a politician and gets them to decide in favor of their interests and short circuits this complex process, which the Federalists thought was designed to not get us to advance our self-interest so easily. It would force us to work together. If you have a lot of money, you short circuit that process and you get somebody to just work on your behalf. The conservative wing of the court has been increasingly skeptical of corruption as a reason for upholding restraints on spending. They still believe that there is corruption. But their view of corruption, it has to be a quid pro quo. You have to give me a suitcase of money and I have to vote for your construction project, right? Which, right, or whatever, right? Or you guys can just give me a suitcase of money. I just want to say that as an aside. Right, I'm open to accepting suitcases of money. But you can, so that's very hard to show.
But we're not stupid.
But we're not stupid, right? You're not stupid, right? And so I mean, I think this is the problem, is it's not so much about, it's in part about this movement in precedent towards a stronger free speech jurisprudence is something that has been built jointly by the liberals and conservatives on the bench. But it's this underlying attenuation of, particularly among the conservatives on the bench, that there's such a thing as corruption, and that corruption can be a reason for restraining contributions that has made the difference. And I'm not sure what's driving that. I mean, you might say, oh, well, it's convenient because it allows, I mean, if you have a partisan explanation, you could say, well, it allows money to flow from conservative sources in the elections. I guess you could look at it that way. I think something else that might be a piece is that no one on the court anymore has any political experience. There used to be a time, not so long ago, that our Supreme Court justices were often, had been distinguished public officials. Presidents even, for crying out loud, right? And these are people who had been in leadership positions, that stood for elections, and legislated, who knew how politics worked, how it could succeed, how it could fail. Our Supreme Court justices now used to be judges on lower courts, or lawyers in government or private practice, right? And they don't have the kind of public official experience. So that may be a piece of what we're seeing here about this changing sense of what counts as corruption, is it reflects the changed biographies of now who sits on our court, right? They're not people who've had lots of experience in the real world of public policy or politics. They're people who maybe are attracted to this very, I could say lawyerly, definition of corruption, which is, let's precisely define it, is an exchange of a vote for money, right? As opposed to, you know, I just like you. I don't know if it's the money you gave me, but I've just taken a shine to you.
Are you saying that the judges are naive?
Well, I think it's that there's, that you could look at it that way, right? I think part of it is that they're steeped in a certain set of professional experiences. So from one perspective, they're naive. From another perspective, they're just top flight lawyers of a certain kind, right? So I don't think that they're children or that they're, you could like kind of easily deceive them or something, but this is another explanation. I think the part of the problem is the justices don't tell us where they're getting this conception of corruption from. They just write in Citizens United that corruption is a very narrow and limited interest and is not a sufficient weight to overcome our commitment to freedom of speech, which includes the freedom to give money. That was a long answer. So, or I don't even know if it was an answer. There's a lot of me talking. Yeah.
Along the lines of Citizens United.
Can't hear you.
Along the lines of the Citizens United situation, I was wondering your opinion about what certain court observers have suggested is the idea that this current court is the most business favorable court possibly in American history. And if that's true, does that have anything to do with the origin of many of the justices coming out of like white shoe law firms, which serve the interests of business and might be then oriented toward their interests? And secondly, if that's true, do the angry white working class people who have sort of gravitated to the Republican Party and Donald Trump or whatever, do they realize anything about that reality, that labor has been on the defensive for years now, and that, as far as the private sector union movement, now the public sector union movement, what do you think is going to happen going forward?
Those are all good questions, right? Sort of big cluster. So let me pick at them, and if I miss something, you can come back and tell me what I missed. So first, the idea that the Supreme Court now is the most business-friendly court possibly ever. First, it's hard to compare across eras sometimes because the issues have changed. The idea that we have a Supreme Court dominated by the corporate bar was first articulated in a very forceful manner in the 1930s, when we did indeed have, which is not to say that it isn't pro-business today, but this is not the first time that this movie has been played, I guess you could say. In the 1930s, you had a court that was strongly opposed to various forms of regulation, both at the federal and at the state level. And the concern among progressive critics of the court at the time is that the corporate bar which was a newly fashioned corporate bar starting in the late 19th century, had really kind of grown and become strong, was reflected in the Supreme Court. So there have been pro-business courts before, it's just number one. But there is, by number of measures, it is a pro-business court today, right? And that pro-business outcome, you can see in a variety of areas. I referred to one earlier on with Dow Chemical. Dow Chemical advancing a suit designed to get the court to make it harder for class action lawsuits to occur. So if we all suffer some kind of small injury at the hands of a large corporation, we can still, as a class, band together, and it's worth our while, even though the injury each of us has suffered small, to band together against that corporation. The court has been making it harder to do class actions. The court has also been making it easier for businesses to have all disputes shunted into arbitration, mandatory arbitration agreements. And arbitration agreements is you give up all kinds of due process rights when you enter that as an individual, and the repeat players in that system, which are the businesses, have an advantage. Having said that, the court doesn't fine for business all the time. In fact, every time a story is run in the press about this being a pro-business court, the U.S. Chamber of Commerce comes out and says, wow, we don't think they're pro-business at all. And often what that means is that we lost one. Right? We won 10, we lost 10. So sometimes pro and anti is a little bit in the eye of the beholder. In terms of connecting it though, right, is there this sense of larger scale consequences of having, say, a court that favors, in this case, business? How does that play out in electoral politics and the decisions people make when they're in a voting booth, whether it's in a primary or in a general election? Do they connect the dots? And for the most part, the answer seems to be no, they do not. And that's because the court is often a very remote consideration in any voting process. Sophisticated people who are engaged in public affairs, the people in this room, right, are aware of the consequences downstream of a particular vote that you might cast for an elected official. But most people are not. Many people vote on the basis of just kind of identity, right? I mean, I'm a Democrat because my dad was a Democrat, or my friends are Republicans, so I kind of vote for Republican. Don't even pay attention to what's going on. Don't vote in most elections until a presidential election comes along. So for the most part, I think people are unaware. And in fact, there was a piece that was just in the paper yesterday about Bernie Sanders supporters. Most Bernie Sanders supporters do not support his policies. What are they voting for, right? It's a statement of identity. Bernie Sanders is exciting. He's just set college campuses on fire, right? Bernie Sanders isn't your grandpa's candidate. Bernie Sanders is a young person's candidate. If you're young or young at heart, you vote for Bernie Sanders, right? That does not say every Bernie Sanders supporter doesn't have any idea what his policies or agree with them, but there's a large number of them that don't, right? So we often vote not because we have done exhaustive research and given due consideration to the pros and cons of the policy positions of our candidates. We vote on the basis of our likes and dislikes, of our petty hatreds and our vanities and passion. I keep coming back to that. I know it's depressing, isn't it? But I think it helps us understand why these connections don't get made, right? So I don't know if that answers all of your question, I hope. Yeah.
We're moving into a season, as you talked about, with the Supreme Court, that many major decisions are going to be made here shortly. And you hear the term or the expression once in a while, people say, well, we're all waiting for the Supreme Court decision, as if this was going to set the direction forever. And I heard or hear, right or wrong, I'm not sure, that's why I'm asking the question, that in some countries that have a judicial system like the Supreme Court, they basically ignore it. I'm not sure that's a correct statement, but I'd be just curious, is there any danger in that sort of thing in this country or not?
Just the court makes a decision and who cares?
Yeah.
Right. I think that's something that the justices and judges worry about a lot. They worry about their own legitimacy, right? Which is, why are people going to obey what we say, right? Most decisions, you immediately have one person who's likely to disobey, a person who lost. Right? So that even before it radiates to a larger public, you already have this concern, how do I keep the loser on board? And this is a challenge for courts everywhere, in any country, at any level, including the US Supreme Court. How do you get people to obey? And I think that this is one thing that might help explain, periodically you'll hear people talk specifically about Chief Justice John Roberts. And now, he's not like, exactly in his voting pattern, other Republican nominees who currently sit on the Supreme Court. His voting pattern is more liberal than you would expect, given the party president that nominated him and his own past biography. Which is not to say John Roberts is a liberal. Okay? He is not a liberal. He has voted twice, provided the saving vote to save Obamacare. But almost all his other votes, he votes very closely with the other conservatives. But he does behave a little bit differently. Why would that be? And I think it's a concern with precisely this problem. Who's going to listen to the court if we think we all know the outcome in advance? And it's just a question of who's got more votes, the Republicans or the Democrats, right? Then the court becomes no more authoritative than a subcommittee in the House of Representatives. We know the outcome in those votes too, right? No one cares, right? We know what people are, those votes become important because they're statements of identity for the person casting the vote, not because the rest of us treat it as authoritative. I think one of the things that is an achievement in the United States, a real achievement that we ought to celebrate, is that we are so litigious. I know people sometimes say it's a bad thing. It's a great thing. It's a great thing because we take our disputes into the system rather than taking them into the streets. One problem with other countries where a court can rule, and people say, who cares, right? We're going to instead riot to get what we want, or boycott to get what we want. is that you are seeking dispute resolution outside of the system. I think the great thing about a Supreme Court decision is when it spawns more arguments about the terms of that decision, right? That's not bad, it's good, because it's feeding people's disputes right back into the system, whether that means filing a new lawsuit, signing a petition, voting for a different candidate, trying to change who the lawmakers are so they can change the law the Supreme Court is interpreting, right? I think those are all good things, because they're channeling our efforts into the institutions that make self-government possible. So I think this is always a concern. Who will listen? Who will obey? It's a concern that's in the minds of the justices, and maybe most in the mind of whoever happens to be the Chief Justice of the Supreme Court at a given time. And I think it's something that we have to worry about, right? If we didn't have judicial legitimacy, I would be concerned that we would lose governmental legitimacy. If you look at public opinion polls, the Supreme Court is almost always, ever since Gallup has been asking this question, the most trusted institution of the federal government, political institution. There are other institutions out there that we more trusted at different times. That's kind of the depository of the public trust. Even if they don't understand what the court is doing, even if they don't connect the dots between, say, a pro-business court and embattled labor movement, right? But that kind of trust is important because it leads to not obedience, but it invests people in the process and invests them in taking their disputes into the system, which I think is a positive thing. Yeah.
People have spoken about term limitations. Isn't that a ridiculous situation in the sense that argued the Senate, is the Congress going to vote against their own jobs?
Right. So, yeah. So term limits. This is why many arguments for term limits usually come from the outside, right? It's just like, how are you going to get somebody to vote against, like, oh yes, I want to vote myself out of a job, and I'm going to give myself a pay cut while I'm at it, right? I mean, so yeah, often you'll have movements. I mean, the progressive movement, for example, in the 20s, or the anti-federalists, right? They were saying, no, we want to structure the system from the get-go, or we want to come in from the outside and impose term limits on its sitting officials. There's now a movement, by the way, movement's probably too strong, to term limit the Supreme Court. There is talk of taking Supreme Court justices and treating them more like the director of the Fed, right? And giving the Supreme Court justices 18-year terms. Now, that's pretty long, but it's not for life. And the idea is that it'd be long enough that a president could nominate and the Senate could take seriously filling the seat, and your point of view on certain matters would be reflected for 18 years on the bench. But any president who comes in, or any new Senate majority that comes in, could have hope in a regular, predictable fashion that vacancies would emerge on the bench. And so we could avoid situations like we're currently in. Now again, where would that come from? Who's going to do it? Members of the Supreme Court are not going to term limit themselves. Even if Congress approved a bill and the president signed term limits of the Supreme Court, it's likely the Supreme Court would strike it down. Right? So where is it going to come from? It would come from us amending the Constitution. Now the Federalists made amendment to the Constitution extremely difficult. There have been over 10,000 proposals for constitutional amendments in our nation's history. There are 27 amendments in the Constitution, right? 10 of which were added right out of the gate after the Constitution. So we've had 17 ever since 1791 or whatever, right? It's very hard to amend the Constitution. It does not happen very often. And so that's what it would take to term limit the Supreme Court. But I agree with you. It's sort of the, who would do it? It was funny, I think it was in the 90s, there was a movement among some sitting politicians to term limit. In fact, you had people running with contract, that might have been one of the planks in Newt Gingrich's Contract with America. I think it was term limits, I think. Does anybody else remember that? Contract with America? You don't? I got it tattooed on my back. Hard for me to see. But I think that was one of them, was term limits. Of course, they never followed through on it. Term limits are great when you're running for office, right? But once you're in, you're like, yeah, well, now that I'm here, I can see the value of experience, right? Term limits may not be such a great idea. But keep your eye out. If you see an 18-year term limit for Supreme Court justices, it's an idea that's floating around.
Good idea.
Yeah.
So on that note, do you think the Constitution works in this day and age and will work for the future of America, given the changing demographics and,
Yeah. You know, I think the Constitution, I guess the first piece of it is the Constitution is a document, and constitutionalism in the United States. There are lots of parts of the Constitution that we just don't pay attention to, right? You see this really profoundly if you study constitutional law. Constitutional law is the part of the Constitution that's been litigated. And the Constitution has not, believe it or not, been 100% litigated. There are lots of things in the Constitution that are not subject to legal dispute. Some of the most inspirational parts of the Constitution, the preamble, we the people, no one's sued over that, right? Blessings of liberty, what are those? I'd like one, right? No one's sued over that. So there's the document that is the Constitution, and then there's constitutional law, which is something separate. It refers to only pieces of the Constitution, and it's very dependent upon 2 centuries of precedent. And then there's the constitution of our politics, which can be disconnected from the Constitution altogether. Think about what Donald Trump has done in this primary season, now entering the general election.
Do we have
to? Briefly. Okay. One thing he's done, I think we can all agree, whether you're for Donald Trump or against Donald Trump, is he's broken a lot of rules, right? He's done things very different ways. Now, none of these rules are constitutional, but this is the way we did things. This is the way elections ran within, the parameters. In fact, there's even a book out there called Little Book of Electoral Etiquette. There's an etiquette book for elections. It was written by a journalist who just simply collected, he's like, this is how people behave in elections, right? And it was certain things. It's like, okay, you can criticize your opponent, but you can't criticize your opponent's children, okay? I know, it sounds like an antique document now, but that's part of our Constitution too. Are these about constitutionalism, a set of norms according to which we conduct our public affairs. And those are not, I think as Donald Trump has demonstrated, those are only as strong as people's faith in them and their willingness to adhere to them. So there are parts of constitutionalism in the United States that we can change, and it doesn't require going to Article 6 and getting 3/4 of the states to ratify. It just requires, and it's just interesting, if you look at the media coverage of Trump, at first it was like, he's a buffoon, right? That was in the summer.
He still is.
Right? But it's like, this will never happen. He'll lose. Why will he lose? Because he's a buffoon, right? And then then there was this, oh my God, I can't believe it's happening. And now he's covered like he's a candidate for president of the United States. There's a lot of, now all the coverage is like, who's up and who's down? Is Trump ahead or is Clinton ahead? It's not, oh my God, he's a buffoon, this can't be happening. And so it's almost like, just in the space of 10 months, I would argue, we've reconfigured some elements of our constitutional practice. That is the kind of furniture, the structure by which we conduct our public life, which is not the same as the words in that document, nor the same as constitutional law, which is the litigated parts of the Constitution as embedded in 2 centuries of precedent. So I think it kind of depends, the way I would approach your question is to sort of think about what level or kind of constitutionalism we're talking about and interested in. And this could either make us feel better or a lot worse about our future, right? So I think we're, in a way, we're seeing part of our stable political practice change right now before our very eyes. For the better, for the worse.
Do you feel that we're at a critical point and that we're at a very dangerous critical point here in this country with everything that's going on?
My own view is I don't see conflict as a bad thing. I think conflict is the engine of self-government, right? Conflict is what drives us to confront one another. And I think so long as conflict, as I was saying earlier, is fed back into governing institutions, we're in good shape. Does that mean that those institutions are always going to be the same? Does it mean, for example, that the primary system next time around is going to look the same as it looks right now? I don't think so. The primary system as it exists right now was a product of the 1970s. The primary system didn't used to exist at all. Estes Kefauver ran all these primaries, won. Do you remember the Kefauver presidency? Yeah, it didn't happen, right? It didn't matter that he won the primaries. Who cared? It was all decided in the convention. So I think so long as we have groups that are committed to taking their point of view and working it out through the system and established institutions, then we'll be in good shape. Where we have problems is where people seek to exit the system, right? That's when people are exiting the system, when decisions are being made in the streets. That's when I would worry. I don't think that's where we are. Maybe, I don't know, let's say if Trump wins, we can revisit this conversation and see. Change my view, yes.
What is your opinion of what people who are now against Trump, who are making a big, at various rallies, are trying to have their voices heard, and where he decides, that is, Mr. Trump decides that his people will get them out of the meeting hall or outside and get them arrested?
Yeah, you mean, so Lewis referred earlier to this
Right.
speaker series that I run, and this every spring. By the way, you're all welcome to come to this thing. We have food too. I will not offer. Where is it? Lewis can feed you the info.
It's right, it's in the law school. It starts in late January. I'll post it, and it's been extremely, it has been as invigorating for 8 days, as Keith coming and sharing with us this invigorating, expounding, thought-provoking series of different subjects, many different subjects.
So we had John Katko come. We have judges. We have journalists. We've had just about every legal journalist in the United States, both print and broadcast, come. We focus more on law, I guess, as a piece of it, but we do politics and media. But to answer your question, we had a couple of speakers this time who are experts on presidential elections and the presidency, which I am not. But one of the speakers attended rallies for all 17 of the Republican candidates. In fact, he went to a Gilmore rally that Gilmore didn't show up at. So he's been to more rallies. And he said—
Tell him about Matt.
Yeah, this is Matt Dickinson. Matt Dickinson, who's fantastic.
And you can get Matt Dickinson's blog. It's a good generalization of what's going on. And I think if you're into politics, you have some degree of, to do it, is to follow real politics and Politico. You don't have to believe it. Read it to get a scope of what's happening. Because in 6 months or 5 months, it's going to be over with. And it's a living experience that all of us are watching and being involved with. I mean, I'm 73 years old, and I'm glad to see what's going on.
It's called Presidential Power, is this blog. And what he,
Yes.
so he attended all these. And the one thing he said, and it speaks directly to your question, he said, well, his experience, he's been to more than one Trump rally. He's been to, I think, like 5 or 6. And he said, first of all, they're not angry events. They're more kind of like joyous events. And there's a scripted quality to them where there's a certain, it's almost like Stations of the Cross, but happy, right? And so, saying, well, he will say, when I'm in office, we're going to build a wall, and everybody knows this is coming, and who's going to pay for it? And everybody screams, Mexico. And they go through things, and then there's a protester moment where he'll ask, are there protesters out there, right? And people will say, I'll look around and find a protester, and it's this whole kind of almost ritual performance. And because when I cut coverage of it, I just thought, this is horrible. This is kind of a vigilanteism or something. Again, I'm a system-oriented guy outside the system. But the way he was presenting it, based on his experience observing and attending these, is it almost had more of this quality, almost like you could imagine people, not that people do this, but almost like people pretending to be the protesters for the sake of doing the ritual. And he said that what people are getting out of this is this sense of, he gets me. And this is a space here where I feel that someone understands me. And it's very familiar. I know what the steps we're going to go through. We're going to talk about the wall, and we're going to scream Mexico. We're going to find a protester, and we're going to scream, get him out of here, right? We're going to do these things. And he said that, it's of all the rallies he attended, he only saw one other person who created that kind of joyous experience at their rallies. And that other person was Jeb Bush. Which is, you look at the way Jeb Bush just got no traction, right? He went nowhere, and he spent a lot of money going nowhere, right? But I guess the point of it is that the attending these rallies and seeing what they're like can be quite different than the way they get reported. Does that mean that Trump has not said those things from the podium about protesters? I'll hit him myself, or I'll pay for your legal fees. No, he's actually said those things. Does it mean that those things are admirable and that we should seek to imitate them, proliferate them? No, certainly hope not, right? I would hate to see that become part of the way in which we run elections. But I think it's harder to understand what's going on at Trump rallies and what's going on among Trump supporters if that's the only lens we have.
Right.
Which I was totally unaware of, I have to say, until Matt came and told us this. And Matt's he's a very level-headed guy. The presidential power blog he writes is very informed. They're not short snippets. I mean, it's the longest blog post you've ever seen. You're gonna have to hit your space bar right here many times. But what he's trying to do is present alternative narratives, not in the sense, often when people say alternative narrative, what they mean is, I've got a political point of view, and I just don't see it reflected in the media, so I'm gonna grind my axe here, right? What he means is, let's try to be fair to the facts and find out what's going on so we can understand it. Which means he's not a Trump supporter, right? He's not a Jeb Bush supporter, but he wants to give an account of what's happening there. Which I still don't know what to make of this, that we have this almost like joyous ritual performance.
He also interprets the polls.
He does a great job interpreting the polls too, because something that's happening now, which is maybe a conversation for a different day, but when we say people make decisions, what does that mean? Well, we have elections. That's one way we know what people think. They vote, right? But there's a continuous construction of who the people are through polling, right? We have continually construct our voice through polls. We're told what we think all the time based on these polls, which is weird when you think about it. It's like, who are the people? The people are people who answered polls. And what did those polls say? Well, this is what they said. Oh, I guess that's what I think, right? And so I figure out what I think by reading about what the polls are. So it's a loop. I think we just take it for granted, right? But the polls themselves can be inaccurate and poorly constructed in and of themselves. But they also, the way in which they're assembled into the voice of the people, what people think, is a political process. And Matt's also very good at that. So we're going way beyond anything I can do about, but I would just, this is a plug for Matt Dickinson's Presidential Power blog. Yes, sir?
When the candidates make statements that are patently false, is that litigious?
No. And the reason why is, in part, let's go back to this pro-free speech environment. It used to be easier in the United States, and still easier in certain countries, like in England, for example, to sue people because their false statements tarnish your reputation. So, in particular, it's not just sort of saying the sky is orange, but saying, Bybee's an idiot, right? And the Supreme Court in the 1960s, is a very important decision, said we can't allow people to sue on the basis of false statements. And the reason why is because, and this is probably one of the most important ideas, constitutional ideas, and it's not in the Constitution, but it's probably one of the most important ideas in our constitutional law, is that if we allow people to sue or to somehow censor speech, that will chill the speech of others. This idea of chilling, that if Donald Trump gets sued, it might make Hillary Clinton sort of pull her punches on the stump. It might make, Mayor of Fayetteville less willing to say hard truths about the necessity of wastewater management. It has a chilling effect, this is the idea, on everybody else's speech. So the Supreme Court decided that in order to keep debate on public issues robust, uninhibited, and wide open, which I know sounds like a dating profile or something, right? Robust, uninhibited, and wide open, we cannot allow people to sue when there are lies said in public, unless it's so egregious, right? So if it's done with malice, And you just did the actual malice, disregard whether it was true or not. So in extreme instances, yes.
So the door's
And
open.
the door's open. And the door's open wider if the person that's being lied about is a private person rather than a public official, right? Or some kind of public persona. So, I'm more likely to be able to sue if someone says Bybee is an idiot than if Trump is if someone says Trump is an idiot. So, but the idea behind this, again, is this idea of chilling. If we allow any element of speech to be policed or shut down or censored, it's not so much that that speech in and of itself is problematic. Like if somebody denies the Holocaust, right? You might say we want to get rid of that. We want people to not deny the Holocaust. The chilling idea is that if we allow that to be denied or censored, then people will stop talking. See, well, Lewis doesn't feel chilled by my speech. Yes.
I'm getting, Lewis, start it up.
Okay. Yes.
The Carol Burnett case was one of the few where she was a private person.
That's right. Carol Burnett won a libel suit. I mean, right now what we're seeing is, I don't know if you were following the Gawker case. Hulk Hogan?
Yeah.
So Hulk Hogan is suing Gawker Media for broadcasting these sex tapes. He won, and he's suing again. And yeah, he got a $100 million settlement. It just came out the other day that his lawsuit's being bankrolled by Thiel, who's one of the co-founders of Facebook. I don't know why, what's going on there. But this is an area of within First Amendment law that's really in ferment. And it's because after this 1968 decision, New York Times v. Sullivan, we entered a period all the way up until pretty much right around the current day, where it's extremely hard to win a defamation lawsuit, particularly if you're a public person. And that's why you had really famous people exporting their defamation lawsuits to England. Many stars have sued in England. Rock stars do this all the time. Right? They take it to England because they have different standard there. But now we have, what is the media has changed. In 1968, right, we had a limited number of channels, we had a limited number of newspapers, but it wasn't even just the number, it was the ethos, it was the ethic, it was the commitment, not so much to objectivity in the sense that the reporters were objective, but objectivity in the sense that they followed this discipline of verification designed to, as much as possible, be clear about and accurate about the facts. That's no longer a universally shared ethic, right? Gawker wasn't showing these tapes because there was any kind of, they did showing because they wanted to get clicks, they wanted to get eyeballs to their site. So as the media's changed, we've seen more and more pressure on this very tough, very high wall against defamation suits. And they're beginning to see breaches in this wall and changes in how the courts treat defamation suits, and they're becoming more friendly. So I think we can expect to see over time more of these, more litigation around invasion of privacy, around defamation, slander, all these kinds of things are going to get bigger. And people who are advocates of free speech are worried about this, very worried about this, because they're worried that these successful lawsuits will chill, again, that important 20th century idea, everybody else's speech. But it's something that's changing. And I think you had Roy Gutterman here once. Did you have Roy Gutterman?
Times.
Okay, so this is what Roy does.
Is this gonna hurt our supermarket checkout aisle experience?
I certainly hope not. That's where I get all my questions. That's exactly right.
From my perspective, I am sure you guys are going to have dinner tonight and you're going to know everything about the Supreme Court, politics, Trump, and remember all the details that Keith has so expertly articulated to us this afternoon.
Thank you.
I can't thank you. Next week,